Welcome to Esca Legal Lounge. My name is Kimber Marie. I'm an associate here at Esca, and today I am joined by our of counsel, James Slater. Hi, James. How are you today?
Good, good. Thanks for having me, Kimberly.
Yeah, thank you so much for your time. I'm looking forward to today's subject, which we're going to demystify a little bit litigation, specifically IP litigation. So we're just gonna dive right in. The first question I had for you is if you were to break down the litigation process for a client, how would you describe that?
Yeah, so litigation, it's going to be dependent, we're talking the IP context, right? So we're in federal
Correct.
court, and it's going to be, the timeline is going to be dependent in some respects on which court you're practicing in. A lot of my practice is in the Southern District of Florida. When you file a lawsuit there, once you serve the defendants, a lot of the judges are giving you about 10 months until your trial term. So that's a pretty short period of time. Other districts, you might be 2 or 3 years, maybe even longer before you're getting to a trial period. So, it starts out, you file your complaint if you're the plaintiff side, and some in some IP matters, you might be, immediately filing a TRO, an ex parte TRO, a motion for preliminary injunction shortly thereafter. And so, in some contexts, these cases are very hot, very fast paced, and there's a lot going on at the get go. Other types of cases you may not be seeking injunctive relief off the bat, in which case the other side would respond, either answer the complaint, seek a dismissal on whatever ground that they may try to dismiss the case. And if you get through that phase of litigation, then you enter into discovery, which is usually the longest. And unless you're sort of fighting over a TRO or preliminary injunction, usually the most expensive part of a case because you're going into a lot of e-discovery, possibly depositions, things like that. And then after that, if you get through the discovery period and you don't settle your case, then you're into summary judgment. Either side can move for summary judgment. Usually, the defense will try to basically shut the door on your claims, getting you to a jury if you've sought a jury trial. And then sometimes the plaintiff will move for summary judgment on liability. Basically, the defendant did it, they're wrong. The court can decide that based on the undisputed evidence, and so we should just have a trial on damages, for instance. Once you're through that phase, then it's trial time.
Nice. Lots of moving parts.
Yeah.
So what would be the pros and cons of litigation, and are there any alternatives to it?
So in the IP context, and we do a lot of trademark litigation at ESCA, and in some contexts, like in a copyright dispute, there's not this sort of use it or lose it principle, right? Like you have a copyright interest in a work that you are either the author or owner of, and you can enforce that as you see fit. The only limitation on enforcement is if you don't enforce it, then you can't recover damages for that period of time. In the trademark context, it's sort of you have to police your mark. And so one of the biggest considerations or a consideration in some of these cases is, okay, there's this other player out there. You have a registration for your trademark. You're using your trademark, great, because if you don't use it, you lose it. You're using it in commerce. And so have you let the other side know that they're infringing, right? Have they been out there in the marketplace for many years selling the same, selling a product in the same class as you under a similar name? If so, you might have waited too long. They might have a defense in your case. And so it's really the best sort of strategy in like the trademark context is if as soon as you identify a problem, you need to take action. You need to be proactive because if you wait too long, there could be some risks in litigation. Another consideration is, and I come from at ESCA we do a lot of we right now at least a lot of primarily plaintiff side trademark litigation, but I come from primarily a defense background prior to this, and so from a defensive posture. you might be looking at, hey, can we cancel the registration? Can we file a counterclaim and try to eliminate that or try to gain leverage through a cancellation proceeding? So one thing to think about when you're having someone else in the marketplace, if I don't proceed, I might not be able to get them out of the marketplace. I might not be able to do anything down the road. I might be barred. But if I do something and I'm not so sure about the strength of my trademark, do I risk a cancellation proceeding? Um, and so there's a lot of considerations that go into it, and so it's always helpful to have able counsel to advise you on these risks because I don't know how many times I've been in a case where there's a cancel, all of a sudden someone's trying to cancel your trademark and the other side didn't even consider that as a possibility, and it completely changes the landscape. So that's sort of something that we have to think about when we get into these cases. Are there any defenses? Are there any possible counterclaims? With respect to alternatives to litigation, obviously folks can resolve things. We resolve a lot of issues pre-suit, right? Not everything gets to court. Court is very expensive, especially if you're seeking a TRO or something like that. That gets very expensive, very fast moving. But if in a lot of cases we're able to resolve these things, especially if you have good evidence of your use of the mark, if the person has been put on notice and doesn't do anything, and if they get a good lawyer on the other side, usually we can resolve these things without having to go to court, which costs everyone a lot of money. And so my inclination is always to try to see what we can do outside of court, because the last thing I'd want to do is spend all my clients' money and then maybe we're in a situation where we're not getting the result we wanted because the other side's fighting back or something like that. So it's always helpful to sort of look at the bigger picture, and advise your client on the risks, because there may be an alternative to litigation. Based on some of those risks, you may decide we want to just settle pre-suit, try to coexist, whatever the answer is, to try to avoid some of the downsides of litigation.
That's great. Thank you for that. And thank you for emphasizing the cost concerns with litigation, because just from what I've heard so far in research, that tends to be like a big surprise for people. Like, I think there's like a general expectation that it is expensive until you're going through it, maybe, and then you don't realize just how expensive it can be. But another misconception I've noticed people have is how long litigation can take. Can you kind of speak to all these moving parts you've described? Usually, like, what is the timeline like for those moving parts like?
Yeah, so there's always opportunity. There are always opportunities to resolve cases before suit, during suit, and so it really depends, right? Sometimes the other side just isn't in the same universe as you or your client. And so, a lot of these cases will resolve, or at least in my experience, when they're not close calls earlier on, right? Because, either the other side just doesn't have the resources to litigate, or it's so clear that there's infringement that the other side realizes there might be some real risks and downsides, right? But if that's not the case, right, if it's kind of a close question, or if the other side has a lot of resources and doesn't want to give up what they're doing, it could be years, which I think a lot of folks don't realize, right? I mean,
Yeah.
it's not as long as many places in state court, but it could be several years. You could take an appeal on some of the issues. And so, some of these cases can really drag out.
Wow. Yeah, that is long. And my last question for you is, are there any other misconceptions you often notice people make when it comes to litigation, specifically litigation regarding intellectual property?
Yeah, I think, sometimes people will think that because they own a mark, or they've authored a work that is subject to copyright protection, that they basically can sort of monopolize this concept, or monopolize sort of what they're doing, and that can be a problem. And that can be a problem when you overextend, sort of the protections you have, and try to overextend that in court, because that's an easy way to really, from the defense side, to really go after someone. Hey, they're misusing the copyright, or they don't have rights in this. And so we see that a lot on when I'm on the defense side. On the plaintiff side, the misconception um, sometimes is that defense. Sometimes you think that the defense, if you have a strong case, will just sort of you know drop out of the case, or just give up, right? And sometimes that just doesn't happen, and it's hard to get expectations aligned when the other side thinks, okay, well, this person's clearly infringing, clearly they just need to give up, and they won't, right? And so it kind of going back to what I was saying earlier, the best advice I have is just to find a lawyer who really knows what they're doing. If you have an IP matter, who can explain to you what your rights are, can explain to you what the litigation landscape is going to look like if you have to file, and can explain to you what the risks are. A lot of times we see folks, in these cases, who really have no IP background, the lawyers, and that's a problem, because they just either they don't know how to litigate in federal court, which is it can be a problem, or they just don't understand their clients' rights, and how they would apply to the case at hand. So that's the biggest sort of takeaway I have, is find someone who can really explain to you how this is all going to go down, and what your chances are, sort of getting what you want, because otherwise you might end up in a case that you thought you were going to be really successful in, and you're not, because you hired the wrong lawyer, or because you got some bad advice on sort of what the outcome, sort of the picture might look like.
Great. And I do have one quick follow-up on a point you made regarding IP owners who feel perhaps that they can monopolize once they've gotten a registration. So, like, if you are talking to someone that maybe they want to pursue aggressively anyone who is even closely infringing on their IP, like, how would you explain to them, like, yes, you are an IP owner, but you can't overextend. Like, how would you explain I guess the boundary between what's infringing and what isn't infringing to them?
Yeah, so I think the best way to do that is, to go through and explain sort of the risks of overstepping, because the risks are that you lose in court, that maybe you owe the other side attorney's fees, things like that. But also, when you go the next time you go to try to enforce your rights, you might have folks that see that you are trying to do this, and might raise defenses they otherwise wouldn't have raised, in terms of misuse of your IP. And then also, you might see more aggressive litigants try to cancel your rights, your trademark rights, for example, or raise challenges to those rights, because they think that you're just a bully, that you're overextending what you're entitled to protect.
Awesome. Thank you so much for your time, James. This was very helpful, and I know it's going to be very useful for anyone who maybe they've just have had questions about the litigation process. So thank you for your time.
Thank you.